Hello, my name is Peter Rausch. I am an attorney and mediator in Lodi, California. I've been practicing for about 35 years, and I've been solo for about 27 or 28 of those years. I've been a mediator part-time for 10 plus years, and I've been overly trained, taken more classes probably than anybody I know. I know a lot about the science of mediation and the way we train mediators. So I've been asked to speak today about my thoughts and philosophy really related to joint session as opposed to the breakout sessions. I am shamelessly and unabashedly biased in favor of a joint session. I'll just tell you that right off the bat. My experience has been that in the early days of mediation, we always started with a joint session. My training was that you start out with a joint session and you not only, talk about procedure, but you then get people talking a little bit in front of each other, try to break the ice. And then, of course, things get dicey and folks want to make an offer and they feel like they have to do that privately, so they're going to adjourn to the separate rooms. Seems like several years ago, people started getting very turned off to the joint session and didn't want a joint session at all. They wanted to go directly to caucus and breakout sessions. And I never really understood the wisdom of this, because if the mediator is not going to help facilitate a conversation with both of the litigants to the controversy, why have the mediator? Lawyers can do that, make an offer, make a counter offer, and see how far you get and cut a deal. More recently, it seems like many mediators, including many retired judges working for JAMS and ADR services and other mediation services, they don't do joint sessions at all. They come right into the room and they tear right into negotiating, and then we're all surprised when the thing doesn't settle. And the reason it doesn't settle is because we're not mediating. I don't know what we're doing. It's shuttle diplomacy. I think it's an imperative to bring the parties together and do several things. Number one, they have to learn who I am, because they have to relax and they have to develop some rapport, and they have to gain a sense of trust that as a mediator, I can facilitate the conversation, that I'm not biased, and that I'm smart enough to understand what they're really having to resolve in terms of their conflict. And so the joint session is a great opportunity for me to break the ice and lay out a little bit about who I am and how I approach things, and then talk a little bit about the process, right? And then if I can extend that conversation to give everybody a chance to tell me a little bit about who they are, not in the context of the conflict we're trying to resolve, that's important to me, because I have to know who's in the room when things get dicey in the late afternoon as we're trying to cut the deal. And I also want the other side to start to be open-minded and perceive their opponent not as an adversary, but as an actual person in the room, just like them. And by having these joint sessions where we can talk about who we are and what we do, and a little bit about our personal lives, what our hobbies are, what we do in our free time, what kind of family dynamics we come from, those get people sort of off the warpath. And it really changes the tone and the tenor of the conversations that we're going to have when we try to solve for the actual conflict issues. It's also important, I think, to have these joint sessions, because the mediation has to be a process that leads the parties to come to a resolution that they both are willing to buy into. And let's face it, these negotiated settlements are always compromises. People either give up too much or don't get as much as they want, so they're not happy. And what gets them comfortable with that is knowing that the other side is equally uncomfortable with the place they've arrived at. That's sort of the quid pro quo, the consideration for compromise. And it allows people to meet as humans, not as opponents that need to be eliminated, right? The other thing about the joint session is that this is the big issue really. Settling the case is never about the issues that you read about in the pleadings or that you read about in the complaint, the protest, if you will, that's going to bring about the proceeding that we're involved in. Lawyers can talk about what those issues are and what the rules of law are, and the fact patterns can be argued about leading to an outcome. And, if you're going to go to a judge or a jury or an administrative law judge, that's all fine and well. If you're going to settle with somebody, that's all irrelevant. It's nonsense. It's really noise. And what you've got are people in the room that have to come together and leave the room with some kind of an understanding. So figuring out what is that unspoken component to the conflict that is really going to be what we wrestle with to get folks to come together and compromise, that is gleaned in the joint session. It's not something you're going to get in a caucus, and it's not something you're going to get in a brief that a lawyer is going to prepare. The other important point is that more often than not, and it's not always, but many, many times, the resolution isn't the end of the relationship between the parties. And this is especially true in employment situations where there are grievances and where somebody's complaining about the circumstances of their employment, the conditions, whether they got passed over for a raise, whether they're having some conflict with a coworker or a supervisor. These kinds of grievances need to get worked out, but that isn't the end of the relationship. And in many cases, it's the beginning of the relationship. And it always amazes me how often conflict is not set up between adversaries that are going to completely separate and divorce at the end of the battle. Many, many times, I'm going to say more often than not, there's something more, there's something ongoing. So how can you possibly settle a case and not have the opponent in the room when that person has to continue and have some ongoing relationship? And especially in connection with employment related relationships, it's an imperative that that prospective relationship be a healthy one. And so you're not just settling a claim that is on the table that's in a vacuum. It's not put in a nice clean box. It's part of a larger continuum of a team that's consisting of individuals that all have relationships amongst themselves and their perceived relationship to the organization. And all of those things have to work together to resolve the conflict in a way that allows, I guess we could call it a healing event, to allow people to move on past that conflict and work in a cooperative and collaborative way. And I see this all the time also in neighbor disputes, where neighbors get angry with each other over a variety of things, whether it's the falling leaves on a tree, or it's noise, or it's somebody building something, or it's a problem with a fence location. And boy, they can really get angry and adversarial with each other. And you can wonder, like, how could they want to continue to live on the block next to each other? But as things go on and as you get past the conflict, people can really turn the tides. And I've seen relationships come 180 degrees about and become very positive and very healthy in the aftermath of conflict. So again, how do you achieve that if you're not going to get people in the room? So you have a conflict, it's headed for resolution some way. That is going to be a resolution imposed by a third-party authority that is not going to be satisfying to one side or the other, for sure. And most likely, it's not going to be satisfying to either side. And in the context of a relationship that has to continue into the future, you're poisoning the relationship. You're not healing the relationship. So for God's sakes, bring people together and have a conversation. And who cares if it's uncomfortable? I mean, what's going to happen? Somebody's going to file a claim. Somebody's going to bring a lawsuit. They already did that. That's why they're having the mediation. So as long as they're not throwing chairs across the room, let people talk, let them be angry, let them vent. Mediators can control the dynamics and demand respect mutually, but let them have it out, let them vent and let them get past that. And then, let things find their balance and their equilibrium, resolve the conflict that's on the table, and set the parties free to live in a world where, um, it's better than the world they lived in the day before.